in tight, can you see it? Streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces turn stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
You know, guys, I have to come back up here because, you know, whenever I get something like exclusive stuff, I have to put it out because so you guys will know that, you know, your girl put it out first, right? Well, a little birdie just texted me the order, and I said, okay, let me go ahead and go live. You know, members, y'all know who that little birdie is, right? Members, y'all know who the little birdie is. So, but I have the order from yesterday's hearing. All right, let me just put my hey, Courtney, I hadn't seen you in a while. So here's the order, y'all, that I just got. I just got it when I went off, and I got a little text message, and I got my order. Okay, y'all ready? So here is the order. This was done by Mr. Steele's team, and the judge signed off on it. And here is the order. It says, order granting Jeffrey Williams' motion to dismiss state's appeal and motion for return of property in stir. Okay, so now you guys are going to be the first one to know how his stuff is going to be returned to him. You ready? Okay, you're right. This case is before the court on claimant motion to dismiss state's appeal and motion to return of property, Inster, filed on December 18, 2025. The court conducted a hearing on said motion on January 6, 2026. For the reasons articulated below, the court hereby grants claimant's motion in its entirety. Y'all hear that? In its entirety. Okay? Procedural history. On August 18, 2025, the court conducted a final forfeiture hearing in the above referenced case. And after the introduction of evidence and hearing argument, this court granted Mr. Williams' motion to dismiss the state forfeiture claimant. A final order granting motion to dismiss forfeiture claimant was entered on August 22nd, 2025. Right? On or about September 19, 2025, the state filed a notice of appeal from the court's August 22nd, 2025 order. The notice of appeal specifically stated, listen y'all, the state's request that the clerk will omit nothing from the record on appeal. Additionally, the note of appeal contains the statement, the state requests any and all transcript filed into this case be sent to the appellate court as part of the record of this case, specifically relevant to the appeal, to this appeal is a transcript of hearing which took place on or about August 18, 2025. Prior to the August 18, 2025 hearing, the court informed the parties via email that the court would not provide a court reporter for the hearing, and that if the parties desired to have the proceeding taken down, the party would be responsible for obtaining a court reporter at their own expense. Mr. Williams' counsel's office contact counsel for the state of Georgia and inquire if the state desired to have the proceeding taken down. And if so, whether the state wanted to share its take down expenses, right? The state did not respond to the inquiries, thus rejecting by silence the offer to jointly retain the services of the court reporter. Thereafter, the state never sought to share in the expenses of the court reporter. Mr. Williams alone secured and paid for the court reporter to present and take down the August 18, 2025 hearing. After the hearing, in which the state forfeiture complaint was dismissed on September 19, 2025, the counsel for the state asked claimant counsel for the name and contact information of the court reporter whom Mr. Williams had secured for this proceeding. The counsel's office provided this information to the state on September 24, 2025. Well, within 30-day period in which the state was to have the transcript of evidence and proceeding prepared and filed so as to be included in the record of appeal, pursuant to OCGA 5-6-42. Okay? On October 20th, 2025, the last day permitted by law to file the relevant transcript, the state filed its first motion to extend deadline to file transcript and represented to this court that an extension of 30 days or until November 19, 2025 should be enough time for the court's reporter to finish and file this transcript. The implication of this statement was that the relevant transcript had been ordered and that the court reporter had indicated that she would complete and file the transcript on or before November 19th, 2025. The court did not enter an order on the state's motion to extend the deadline to file transcript filed on October 20th, 2025. As a courtesy copy of the motion was not emailed to the court as required by the court's standing order, and the state did not otherwise make the court aware of the motion for extension. On November 19, 2025, the state of Georgia filed a second motion to extend deadline to file transcript. In the state's second motion to extend deadline to file transcript, the state of Georgia represented to the court that an additional 60 days from the original deadline or until December 19, 2025. The 2025 should be enough time for the court reporter to finish and file this transcript. Again, the implication of this statement was that the transcript had been ordered and the court reporter estimated that she would be able to complete and file this transcript on or before December 19, 2025. The state again failed to email a courtesy copy and file this transcript on or before December 19th, 2025. The state again failed to email. Okay, I said that already. I gotta go back. I lost my spot. Motion of the court to require by the court standing order or otherwise make the court aware of the motion for extension. The court discovered the motion during a routine review of the docket, and based on the representation of the state made in the motion, this court granted the state's motion to file the transcript on or before December 19th, but specifically warned that no additional extension of time would be granted unless for good cause. Subsequently, complainant filed the instant motion noting that as of December 18, 2025, filing date, the state had never actually contacted the court reporter to order the transcript. Claimant submitted an affidavit from the court's reporter's company in support of the motion, which avert that the state never contacted the court reporter or the court reporter's agency. In fact, it is the position that the court reporting company that because the state did not share in the takedown expenses, the state lacked the ability to order a transcript of the proceedings. At the hearing held on January 6, 2026, the state stipulated that the affidavit mentioned above was true and accurate in all details. The state acknowledged that it had never contacted the court reporter to order the transcript, despite the representation made in its two motion to extend the time for filing the transcript. So y'all, they lied. They lied. They lied. They lied on the oath. Okay, let me shut up. Okay. The state's only argument was the appeal should be permitted to proceed despite the ongoing delay in transmission of the record. Over 75 days by the time the hearing on the motion to dismiss the appeal. Because it did not act out of malice towards the court. Remember I said that yesterday? Remember I said that, right? In my little reporting. You know, folks didn't mention all that. I did. Okay, yeah, I had to do a little side note. Sorry, y'all. I had to do a side note. My bad. But anyway, because that's what happened when you're there, you can give the actual reporting of what happened, right? And I said it. Okay. Shout out to Mr. Steele. Okay. All right. That because it did not act out of malice towards the court, opposing counsel, or the claimants. The state did not attempt to address how the delay caused solely by the court's action was not unreasonable or inexcusable. Legal analysis. Number 2. Where there is a transcript of evidence and proceeding to be included in the record on appeal, the appellant shall cause the transcript to be prepared and filed within 30 days after filing the notice of appeal. OCGA 5-6-42. The statutory duty to file timely a transcript does not rest with the court reporter. Rather, the duty to order the transcript and to monitor timely the progress of the court reporter's office in transcript preparation is vetted upon the appropriate appealing party. Jackson versus Beach Aircraft Corp. And gave case numbers on that. Also, Ashley versus JP Morgan Chase Bank. And they gave a case number on that. In normal courses, appellants are not accountable for delays caused by clerk of court or court reporter after the transcript has been ordered properly. However, appellants are held accountable only for delays that they cause. Morrell versus Western Services, and that's a case on that. Pistachio versus Fresco, that's a case on that. All right. No appeal shall be dismissed by the appellant court, nor consideration of any error therein refused because of failure of any party to cause a transcript of evidence and proceedings to be filed within the time allowed by law and order of court. But the trial court may, after notice and opportunity for hearing, order the appeal to be dismissed where there is an unreasonable delay in the filing of the transcript. And it is shown that the delay was inexcusable and was caused by such party. Trial court have very broad discretion when deciding whether to dismiss an appeal for delay. Keeble versus Cobb County. In cases where the non-moving party seeks dismissal of appeal based upon the failure of the appealing party to comply with the OCGA 5-6-42, the issue to be analyzed are straightforward. 1. Has been an unreasonable delay in filing of the transcript. 2. Was that delay inexcusable? 3. Was the delay caused by the party prosecuting the appeal? Pistachio versus Franco, and the case law is on that. As the court ruled at the hearing, after the state failed to contest any of these prongs, all 3 requirements have been established. First, there was an unreasonable delay in the filing of the transcript because the transcript was still not filed over 90 days after it was due. In fact, the transcript was never ordered. Ooh. Okay, here's a footnote on here. Footnote says the state attempted an end run around instant motion to dismiss appeal by filing an amended notice of appeal on December 22nd, 2025, while this motion of this dismiss appeal was pending, but before it had been heard. That filing disclaimed any need for the transcript and requested that the record be transmitted without the transcript. The claimant moved to stay transmission of the record pursuant to the amended notice of appeal, which the court granted until it could hold the hearing already scheduled on the instant motion to dismiss appeal. The court notes that the state's amended notice of appeal was filed 3 days after the last established deadline for filing the transcript, and does not appear to the court that from the docket that the state ever paid the bill to cost of the appeal. The question of whether the delay was unreasonable refers principally on the length and effect of the delay rather than the cause of the delay. Adam versus Herbert. Here, the claimant had been prejudiced by the state's delay because the state appeal would likely be docketed in a later term than it would have been had the state complied with its duty to timely obtain and file the transcript. This is an unreasonable delay. See Pistachio versus Franco. The 3-month delay was discernibly delayed docketing of the record in the appellant court and prevented an appellant decision on the merits at the earliest possible date. Morale, and there's a case law in there, holding that 51-day delays cause delay of appeal from one term to another. Adam is another case here, and it says, concluding that 150 days resulting in delay docketing from one term to another. And Postel versus Alpha, that says holding a 4.5-month delay was unreasonable and delay docketed in the appellate court. That McAster versus Amber Sampson concluded that delay resulted docketing later than a term of court. And then Bush versus Reed, holding that 10-month delay prevented the case from being docketed and heard in the earliest possible appellant term of court. Secondly, the delay was inexcusable. The ordinary signification applied to the word inexcusable is that the conduct by act or omission was not excusable, incapable of being justified. Webster's Encyclopedia Abridged Dictionary in the English Language, 1989, Jackson versus Breach Aircraft. At the January 6, 2026 hearing, the state admitted that it has no excuse for its failure to comply. Y'all hear this? They had no excuse. To repeatedly request extension over a period of months without making any efforts, much less a diligent inquiry as to the transcription status with the court reporter or the court reporting company, constitute a lack of reasonable justification, and the state's conduct is inexcusable. See Carabara versus Fortress. There, the state averted in its notice of appeal that transcripts would be included with the record for an appeal, but never ordered or paid for the transcript, and during that time, they wholly shirked their responsibility to obtain the transcript as required by law and remain in contact with the court reporter about progress. Cabrera, here, that's a case law they just mentioned. Here, the state admitted that it had no excuse for the failure to order the transcript or for its misrepresentation to the court. Remember, I told you that, y'all. I told you, misrepresentation to the court. Koptic did not seek an extension of time, but to file the hearing transcript, but apparently never communicated to the court reporter during the 9 months period between the hearing and filing the motion to dismiss. The state did seek the required extension of time, which is one of the factors considered in the whether the delay in filing a transcript is unreasonable and inexcusable. However, the failure to ever contact the court reporter or the court reporting company to order the transcript, combined with misinforming the court and the parties in their motion not once but twice, which with the unfounded representation that with the requested extension, the transcript would be filed. It is fatal to the state in the analysis of whether the delay is unreasonable and inexcusable. Mercer versus Munn. Failure to demonstrate that delay is contacting the court reporter to order the transcript was excusable results in a dismissal of appeal. Finally, the delay was caused by the state. As the final issue, the facts are indisputable. The state filed a notice of appeal and bore the responsibility to order any transcript of evidence and proceeding to ensure that it is timely filed. Kelly versus Larson. That's a case filed on that. The entirety of the delay has been solely caused by the state. Prior to August 18, 2025 hearing, the state rejected participation in takedown and or sharing the expense of the court reporter. And as admitted at the hearing on the instant motion, the state has never taken any affirmative steps whatsoever to contact the court reporter or the court reporting company or otherwise order the transcript. See Norman versus State, and that's a case law there. Because Norman's counsel failed to properly request a transcript and conceded that he did not communicate about the status of the case with the trial court, the state, the clerk office, or the court reporting after filing the notice of appeal, there was no abuse of discretion in the trial's court dismissal of the appeal. Justice delay even one day is justice denied. In the litigant who was successful in the lower courts and who is entitled to his judgment unless his case is properly reversed. SDM Investment Group LLC versus HBN Media Inc. That's a case law. Delay unreasonable as it caused the appeal to be docketed in a later term of court. As shown above, one, there has been an unreasonable delay in the filing of the transcript for the forfeiture hearing as required by the notice of appeal. 2, there's a footnote 2. Number 2, this delay was inexcusable and prejudicial to claimant. And 3, this delay was solely caused by the state. Mr. William has been prejudiced as he continued to be deprived of his property. Thus, the court orders the state appeal to be dismissed. And here's a footnote, y'all. Here's a footnote. The footnote says, as the state belated the arguable out of time admitted notice of appeal discussed above, the Court of Appeal has in at least one case found the subsequent decision that the transcript was unnecessary for the appeal did not remedy the delay caused by the failure to timely obtain it. CSDM Corp Investment Corp Group LLC. But none of the foregoing findings by the trial court are sufficient excuses under Georgia law for significantly delaying the docket of appeal. Importantly, after failing to file the transcript for 5 months, the defendant waited for 2 additional months after HBN filed its motion to dismiss the appeal to inform the court that the transcript was suddenly no longer necessary for the appeal. Number 3, return of property. This is what y'all been waiting on. This is what y'all been waiting on. Okay? This is what everybody been waiting on. Okay? Here it is. Y'all cheated. Y'all saw the answer, right? Y'all saw it. Okay. Here it is. Return of property. Now y'all see the date? The state is also ordered to return claimant property by 5 p.m. January 9th, 2026. That is on Friday. They have till 9 p.m. Didn't I say that on my live? Didn't I say they had until Friday to return it? Didn't I say that? All right, didn't I say that? I said it, but people didn't want to listen to me. I told y'all, Okay, yeah, let me finish. Okay, y'all ready? Y'all hear this? Now, watch these people that's stealing my information is going to go and put it out now, y'all, right? They're going to put it out. There's 60 of y'all in here, right? But let me tell you, tomorrow when we wake up, you're going to see all these people coming out saying, oh, you got till 5 o'clock on Friday to turn the thing. And watch they say that. Watch. You watch, y'all. You see this? It's only 60 people in here. Watch tomorrow. The whole social media is going to go in an uproar telling it's going to be 6 o'clock or 5 o'clock. Watch. And y'all better tell them, y'all better give it the credit to Sylvia, infamous Sylvia. She's the one who read it here. She's the one who got the document, right? Okay, the order. All right. And I got the order from you know who. I can't tell you who knew you know who. I got the order. Just know that. Okay. So just make sure you tell them, hey, they need the credit because they didn't credit me for being the only person in the courtroom to give that information, y'all. They didn't do that. Okay? They didn't do that. They stole my stuff and didn't even give me credit. All right. So by 5 o'clock on Friday, y'all, that's the answer. They have to return all his stuff by Friday, 5 o'clock, all the stuff. Okay, Mr. William and his designee. So that's why Jeffrey is still here in town, so he can get his stuff. He's here in town to get his stuff. He wants his stuff. He wants his cars. He wants his money. He wants his jewelry. He wants his stuff. You know what? Let me see if his dad is available. Hold on a second. Let me see if his dad is available. You call him and tell him, hey, he wants this stuff. But they probably already know. They got the paperwork already. They got the paperwork. Never mind. I forgot. The attorney probably gave it to him already. Okay. On entry of judgment, for a person claiming an interest in the property that is subject to civil forfeiture proceeding, the court shall order the property and interest of the property be released and delivered promptly to the person free of liens and encumbrances. OCGA 9-16-18B. Emphasis added. Courts are required to strictly construe the forfeiture status against the state as they are quasi-criminal proceedings that are disfavorable by the law. State versus Henderson. All right. Forfeiture in quasi-criminal proceeding that permanently extinguishes a property's owner's right to certain property and accordingly, the forfeiture status must be strictly construed against the state. Omitted. Quotation omitted. Okay. The court entered a judgment in claimant's favor by dismissing the forfeiture claimant. Okay. This strictly construing 9-16-18B. The court finds that the plain language of statute requires that the claimant's property be returned promptly. Hello? Return promptly. Do y'all hear that? Promptly. Free of liens and encumbrances. person. The state has not identified any authority that would allow it to retain custody of the property where the forfeiture claimant has been dismissed, and now the state's appeal of the dismissal has been dismissed. Okay? All right. Even if the state were to file a notice of appeal to challenge the appeal of its appeal, there is no basis for determining that such a notice of appeal would operate as a supersedings or would permit the state to retain the property. Instead, canon of statutory construction weigh heavily in favor of returning the property to the claimant, with notwithstanding such an appeal. In both OCGA 5-6-34B and 5-6-45, the legislator provided that a notice of appeal shall act as a supersedings and shall serve as a supersedings. However, the legislator did not include any such language or otherwise identify any basis for staying and underlying under dismissing the complainant in the fact of this case. Y'all hear that? Court presumes that the legislation act intentionally and uses language intentionally. See Atlanta versus City of Council. Y'all make sure y'all share this live over there and X and everywhere else, and let these folks know it was me that's putting this out. Okay, y'all. You're my people who's on X, who's on IG, who's on Facebook. Please make sure you guys share this live, because so I will get my credit due to infamous Sylvia. Okay, y'all, because these folks like to, act like it's them that's putting out the information, because there's only 67 people in here. But watch tomorrow when it goes out, you're going to see a whole bunch of people. And then let me tell you something, and they're not the one who put this out. Okay. I'm so like ticked off because I was the only one in the courthouse, the only one, y'all. And what did they do? They act like it was them that was there. It's pissing me off. It's pissing me off, y'all. It's really pissing me off, because I'm telling y'all, it was nobody in that courtroom. I promise you, God is my witness. Nobody was in that courtroom but me. But then you see all these big bloggers putting out the news, and I'm like, y'all didn't even credit infamous Sylvia for getting out the news, because I was the only one there. I'm serious, Kim. I'm serious. Am I live on all platforms? No, I'm not live on all platforms. And the thing is, this has not even been public yet. So, and I got a copy of it. I was sent a copy of it. That's why his team wanted me to put it out. You know what I'm saying? Because I was there. They appreciate me being there, covering it. Okay, let me go back. Oh, we almost finished, y'all. We're on page 9. Where are we at? Because then I had to go in my soapbox for a second. And I don't get the views, because I see other people getting 12,000, 40,000, 50,000 on my information that I put out. And what did I get? I got 2,000 views yesterday. 2,000 views on stuff that I put out. That's sad. That's really sad. 2,000 views while everybody else is getting secondhand information from me, and they get all these views. That's sad. Let me add Twitter on here. Hold on, let me add Twitter. Okay. Twitter folks, if you just getting on, it's on Twitter. Thank you, Lynette. Thank you. Lynette, you just posted on Twitter for me? You just did that for me? Thank you, Lynette. Okay, let's see. Yes, please, y'all, make sure you guys share this. Twitter folks, if you just coming in, I am reading the final page of the order that was done from yesterday for thank you, Pamela, for the forfeiture. It is said that the state has to give Jeffrey back his stuff by 5 o'clock tomorrow. I mean, not tomorrow, Friday, sorry. 5 o'clock, by 5 o'clock on Friday, the state has to return every single one of his properties back to him by 5 p.m. You said someone already did? Someone who? You said someone already did? Someone already did what? I don't understand, Lynette. Someone already did what? I'm confused. Lynette, please tell me what you're saying. All right. Okay, I don't understand what Lynette is saying. She's delayed behind. But anyway, guys, I'm reading the last page. We've been on here reading it since for about almost an hour. Okay. So the last page, it says claimant withheld. Okay, we already did that part. However, legislature, we said we did that part already. Hold on, let's go down to so he put it out before I put it out. Okay. Because I got the paperwork at 9 o'clock. Okay, so he put it out before I put it out. Okay. All right. He got to it before I did. But I got the email at 9 o'clock. That's the time I got the email. The text. Okay, so he put it out before I did. Okay. All right, so I need to take it off of X then. Okay. But regardless of what, they weren't there. He posted it at 9 o'clock. I mean, he posted it at 10:05. I got it at 9 o'clock, Lynette. I just didn't go on because I was doing my prayer thing at the time when I got it. That's why I didn't post it. But that's okay. But regardless of what, I was there. They weren't. Nobody was there but me. Can we agree on that? I was doing my prayer thing at 9:00. It says he posted it at 10:04 p.m. All right, let me finish reading this. Let's go. Where are we at? Okay, let's just read the last part. According to the state order to return claimant's property, Mr. William, on his designated 5 p.m. Friday, January 9th, 2026. Okay? He said, keep it. Keep what? Keep what, Lynette? I don't understand. I don't know. It's a delay whenever I'm reading your stuff, Lynette. I don't know. It's a delay. All right, but that's it, guys. And I'm trying to understand what you're saying. You said keep it. Keep what? Of course, y'all, I'm never going to get the credit that's due to me. It's never. But that's the way life is anyway. No. Women are never going to get it. Well, a black woman will never get a credit that she deserves. No matter what. Oh, you're welcome, Serena. I'm still confused. She says she's on the West Coast, but I don't get what you're. I don't understand what you're saying. I don't get it. You said you're on the West Coast, but could somebody please explain to me what she's saying? Because I don't understand. I'm not comprehending exactly what she's saying. She's on the West Coast. I don't get. Somebody asked her what coast she was on. I mean, she kept it. No, I just removed it. I'm not trying to do all that. I'm never going to get the credit that I deserve anyway. It doesn't matter. No, it doesn't ever matter. I just told y'all yesterday what happened. I was there. I was the only one there. And what happened? I get 2,000 views, and then people who takes the information from me gets more views. That's the way it is. Okay, just took that off. That's the way it is, period. Probably because 2 p.m. specific time. I don't understand what you're saying, y'all. I'm lost. I'm lost what y'all talking about. I don't know. I don't know what y'all talking about. Because she said 2 p.m. Pacific time. Well, I don't know. I don't understand what 2 p.m. Pacific time has got to do. I don't get it, y'all. I don't get it. Please help me figure out what's going on in the chat. Tyler, thank you. Tyler, are you going to bed right now? Are you going to bed? No, I'm trying to. Okay, I'm trying to figure out why y'all saying 2 and 5 p.m. I'm confused. I'm confused. Why y'all mentioning 2 and 5 p.m.? Oh, we're saying time. Oh, I never even mentioned anything about y'all saying what time. No, I was asking her why she said I'm on the West Coast. Because I didn't, maybe you guys were having conversation in a chat and I just like, okay, let me just mind my business. Let me just mind my business. I'm lost. No, that's the time they have to give it to him by 5 o'clock. By 5 o'clock, not at 5 o'clock. By 5 o'clock. That means anything before 5, they need to have that stuff to him. Before the in the business, they need to get him his stuff. That's what they basically saying. By 5. You said, "Duh." What are you talking about? I didn't even think about no time difference. I'm just. Oh gosh, let me just shut up. This is like okay. y'all. What are you talking about, Kim? What are you talking about? I don't get it. Why is it an issue of time stamp? I mean, I don't get it. What are y'all talking about? I'm so confused. She talking about duh. What are you? I didn't even mention anything about y'all having a time difference. I didn't even say anything. I just asked her why did she say something about she's on the West Coast. That's all I ask. Oh, it's a conversation in the chat. Let me get out of here. Let me just get out of y'all business. Because I don't know what the heck y'all. Let me mind my business and drink my water. Mind my business and drink my water. That's what I'm going to do. I'm minding my business and drink my water. That's what I'm going to do. I'm going to stay out of y'all business. Because I am way off of there. But Tyler, did you leave the room? I wanted to ask you a question, Tyler. Are you gone? I was asking, did you go to bed? No, you need to chill because I didn't even mention anything. You need to chill. Don't be telling me I need to chill. You need to chill. You don't want to talk about duh and all this kind of comment, making crazy comments. But back to Tyler. Tyler, what were you saying? I asked you, Tyler, did you, and don't call me girl. You know I don't like that. You know I don't like that girl stuff because I'm way older than you. Don't call me girl. Tyler, you still in here? That's my pet peeve. I do not like people calling me girl. That is a pet peeve of mine. I do not like that word. Especially somebody that's younger than me calling me girl. I'm like, don't do that. Don't do that. Kind of remind you of slavery days. Don't be calling me girl. No, 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 no. It probably will. See, that's why he's still in town because he was in he's staying right there because he said he has to stay in his apartment while he's here. He can't come out. So he's in Atlanta, but he has to stay in his apartment while he can't go out. I just don't like that. I just don't like anybody calling me girl. I don't like it. Ever since I watched some of those slavery movie and older women being called girl by some kid and younger people, I was like, oh no, we don't do that. Do you think I don't? You know what, Naughty Land? I don't know. I don't know. I think because they were buying time so much, I think some stuff is not around. I think they probably jumped the gun and just sold some stuff and kept some things sold. I think that's the problem. You say you think you should give a concert over the. I don't know if he's gonna do that. He's already given up a lot of his time. He did like how many appearances? He did like 5 last year. 5 appearances. He did the ones at the school with Steele. He did 2 of those. He did a couple of them in the regular high school. And I think that's why the delays was they trying to get his stuff. And that's why they try to do all this stuff now, ordering the transcript and all that kind of stuff. I think that's what it is. He more than satisfied his part of the plea with the free concerts and stuff and the appearances. He did a lot. He did a lot of appearances. He said they had been a fleet of his cars, and think it was all out. Yeah, I think that's what it's been a stall tactic. They had the 149,000, right? Plus some change. They had the motorcycle, the Corvette, the Porsche, the Mercedes Maybach. They have the Mercedes GT. They have the Lamborghini. They had the Grand Cherokee Jeep. They had the Dodge Durango. They had that Spider. They had what else? They had the jury. Now he won't get back the firearms. The firearms he's not going to get that because he's considered a convicted felon. He's not gonna get the firearms back. He's gonna get the clothes. I wonder if they kept those clothes too. The jury, of course. I did not know they could take all of that stuff like that. Are you up crafting? Okay, I'm gonna call you. I didn't know they could take all that stuff like that. I didn't know they could take the clothes. I mean, who want clothes? Why would they take the clothes? But I did mention it on the live that yesterday that the judge did say they would have to return it by then. Okay, y'all. They seized the artwork claiming gang related. Oh yeah, I forgot about that. Yeah, I forgot about the artwork. I forgot about that. Oh yeah. So I don't know about the that watch. I don't know about that. A lot of stuff is missing. Hold on, Ty. But they have some unclaimed property. The guy talked about some unclaimed property that that's still there. So I don't know who they're gonna give it to. That's one of the things that guy mentioned. The guy that was representing the state, he talked about there was a property that was not claimed. I wonder whose stuff that they're I mean could you imagine they probably had a whole warehouse of stuff. Can you imagine? They thought it was in the bank for them. They were gonna keep all that stuff. They jumped the gun. Imagine. Some of those cars gonna have to be like service because they've been sitting so long. I'm talking about the ones that they haven't sold yet. I mean, hopefully it is. Can you imagine? All right, y'all, I'm about to go. I'm gonna go call Missy over here. All right, y'all. Have a good night. Tyler, I'm coming. What if they don't have items? What happened? I don't know. That's a very good question, Tyler. What happens if they don't have the item? What happens if they don't have the item? They probably get sued for it, right? They probably could get sued. I don't know what happens. That's a good question. But anyway, I got to go so I can get up in the morning. I got to get up in the morning. I'll see you guys later. Have a good night. Bye, y'all.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared. Every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars.